All rise. All persons having business before the Honorable Chief Judge and Associate Judges now presiding over the District of Columbia Court of Appeals. Draw near and give your attention. God save this United States and this Honorable Court. This Honorable Court is now in session. Please come to order.
All right. Well, good morning again. I'm joined this morning by Associate Judge Beckwith and Associate Judge Schenker. As I mentioned, we have two matters before the court today, and the first is in re Gene Robinson. Are you ready to proceed?
Yes, thank you.
Okay.
May it please the court. My name is Hillary Lo-Cicero, and I'm here on behalf of the respondent in this matter, Gene Robinson. I'd like to reserve 4 minutes for rebuttal, if I may.
Okay.
So, Chief Judge Blackburn-Rigsby, Judge Beckwith, and Judge Schenker, thank you for this opportunity today to speak on behalf of my client, the respondent, Gene Robinson. In this case, the appellate briefs have focused on two major issues. One is a procedural issue as to whether the hearing committee in this matter acted properly and according to the rules of the board when it sua sponte raised an issue regarding potential unauthorized practice of law some 20 to 30 years prior. The other issue is more substantive. Under the Roundtree test, did Ms. Robinson satisfy her burden to show by clear and convincing evidence that she meets the criteria for readmission? I'd like to focus primarily on the second issue, but of course, I'm more than happy to answer questions about the first issue as well. Here, we settled on a discussion of factor 4 under the Roundtree test, character. Case law tells us that the question really is whether there is evidence that the character traits that led the individual to violate the ethical rules have changed so that the committee can be confident another violation will not occur. That is the key. Unfortunately, in this case, another issue, that being the question of unauthorized practice of law, also became bound up in that character assessment. We can see this in a really practical sense by looking at the hearing committee's opinion. 5 pages of its legal analysis focused on UPL. Another issue, which was the quality of witness testimony, garnered 4.5 lines of text. Where we end up after reading my able colleagues' brief on behalf of the Office of Disciplinary Counsel is a question about whether the hearing committee's decision can be parsed in such a way that its credibility findings regarding Ms. Robinson can still be relied upon, or should be relied upon by this court, even though the primary finding of credibility was bound up with the UPL issue that, for all intents and purposes, I think we all understand based on the briefing, is neutral, if anything, given the new information that Mr. Metzler provided in his brief.
Counsel, as you seem to recognize in your opening lines, the substantive or second point that you're making is inextricably bound up with the first one, I think, in certain ways.
Yes.
And so your position, well, I'm trying to get to your position, which is, could the hearing committee have raised sort of a new issue, claim, whatever you want to call it, and maybe that's important what we call it, but maybe not, asked your client to respond, and then let's put aside here whether there was enough for the hearing committee to determine that there was a UPL violation at some point. Let's say it was, no one has raised this, but we were looking back through the record and we see that you commingled funds based on, bank records. What's your answer to that? And in response, the attorney made a palpably false statement that directly contradicts documentary evidence. And obviously, I'm not saying that that's what happened here. Is it your position that substantively at that point, the hearing committee could not rely on that with respect to Roundtree factor 4? Or is it more just that here the committee essentially found a UPL violation based on nothing in the record or little in the record, and then used that as an adverse credibility finding?
Our position, Your Honor, and that's a very important question, our position is the latter. I agree with my opposing counsel that the hearing committee has the ability to and is entitled to evaluate other issues that may come to light during the process of the hearing or other pleadings. However, I do think their ability to do that is cabined in two ways. First of all, is that under the precedent of In re Greenwald and some other cases, matters that occurred some 20 to 30 years ago have little relevance to a finding of present character. Here, there was a finding of a pattern, and that was the way that the committee sort of brought its finding into the present day. But the pattern finding falls apart when you understand that the UPL issue was decided, as you said, on information simply not in the record. The second is that under Roundtree, this fluid 5-factor test that's all sort of relativistic, the case law tells us that the factors that are most relevant to the type of violation are the ones that should get the most emphasis in the analysis. And here,
Counsel. I didn't mean to interrupt, but
That's fine.
I did want to take you back for a second to Greenwald and Greenwald.
yes,
And Greenwald seems to suggest that an old alleged violation like the UPL violation alleged here should not be considered. But I kind of read it a little more in a more nuanced way, as it goes to the weight of the older violation that you're considering. And so I think a UPL violation could be relevant here. The issue I have here is with whether or not that's been established. And I think, from the briefs of ODC and our look at the record, there's a big question there. But one thing that concerns me is that the hearing committee seemed to use against Ms. Robinson the fact that she denied committing UPL,
yes.
and that she refused to, I guess, own up to it or admit it and recognize her wrongdoing. And that seems to be sort of a circular argument, because here in particular, where it's not clear that there was a violation of whatever the relevant Rule 49C version was at the time, to then use against her the fact that she denied
Yes.
UPL seems concerning here. What do we do with that? She has the burden on the one hand of showing by clear and convincing evidence that she's of good character and fit to be reinstated. What do we do with their finding that she was not taking responsibility for the UPL? And then what is her quantum of evidence that we can find was clear and convincing?
Thank you, Your Honor. This, I think, is really the crux of the whole case. We can see from certain statements within the hearing committee's opinion and recommendation, they determined she had not satisfied factor 4 because of the precise issue you identified, that she did not own up to what they thought she had done wrong. They say, and I believe this is close to a direct quote, "Our concern about Ms. Robinson's character would have been assuaged had she come in and acknowledged that she violated the UPL and, invented some scenario in her mind where she didn't have to apply to other bars, etc." I think that the answer is looking at the record at the end of the first evidentiary hearing, because that is the point procedurally at which the UPL issue arose when the committee asked for the affidavit. Looking at the record of the first hearing, the committee made positive evaluation of Ms. Robinson's credibility in her testimony. They credited the fact that she did not blame her violation in 2012 and 2013 on the unusual circumstances surrounding it. They credited the fact that she understood the rules and explained that it was hubris that got her in the violation that it did, and that she understood now that it was her fault, etc. As to your second point, I think there are many other things in the record that help to carry Ms. Robinson's burden. She does have witness testimony from two longstanding members of the bar who vouched for her. Now, granted, the hearing committee felt that since they were professional colleagues and not personal, they weren't as persuasive, but in my view, I would argue that it's the opposite.
But I guess that's the hard part for me is once even if we set aside this, the UPL stuff was bad, you still have a hurdle to get over, a burden to show clear and convincing evidence of good character. And what we have is to witness. I agree with your point about the hearing committee's discussion in their report was very small. I think we can know that they really were very focused on this UPL stuff and the way she talked about it. But that doesn't mean once you take that out or don't consider it or think it's improper to consider that the rest gets you there. How do we get over that line?
I think we look to the witness testimony, which, the panel will make a de novo determination of how far that gets her down the football field. The fact that there were positive findings about her credibility during the first hearing. The fact that she was readmitted to the bar of the state of Wisconsin, which used a similar standard and did an investigation and determined she was fit. She's now been licensed there for 5 years. The evidence that the committee talked about that satisfied factors 2 and 3. Also, as this fluid test among the 5, they sort of reinforce one another. She was remorseful. She explained what character traits got her where they did and what she had done to remediate. And then
Counsel, I'm sorry, go ahead. And then.
Oh, no, I'm happy to take your question, Your Honor.
Does the heightened scrutiny, or I don't know if that's the right word, heightened analysis that's triggered by Roundtree Factor 1 mean that your client's showing under Factor 4 with respect to just the witnesses, let's put aside the UPL stuff, had to be greater than in the average case?
I would point to the Bettis decision for some guidance on that, Your Honor. In the Bettis case, it was not heightened scrutiny. It was standard scrutiny. And the court there said, even though the witnesses did not even know about the violations, on the whole, this person has met the standard. Here, as you rightly point out, we are in heightened scrutiny. But Ms. Robinson's witnesses were not like the witnesses in Bettis. They didn't have no knowledge. In fact, they knew intimately well exactly what she did wrong. Mr. John Daniels was a member of the board of directors of the client entity that filed the bar complaint against Ms. Robinson that led to the agreed discipline.
But just so I'm clear, you agree that Factor 4 itself would require some heightened showing. It's just your position is just that it was satisfied here?
I think that heightened scrutiny applies to the entire 5-factor test. I don't believe it applies exclusively to 4 or exclusively to 1. And again, because these factors are all relative, a strong showing on 1 is able to compensate for perhaps a somewhat weaker on 4. And here we also have a woman, I'll point out, who was true to what she believed and remembered about what happened 30 years ago, despite a very difficult hearing where by the end, the committee had made it clear they viewed the law completely differently than she did. But she said, honestly, this is what I remember. And
Can I ask you a question about that?
Yes.
We've been talking about this, aided somewhat by ODC's kind of concessions in their brief, but as if we're setting aside the UPL stuff. But can anything of relevance be gleaned from the hearing committee's, perception of her testimony about those things, even if we ultimately think there's no there?
I don't think so, Your Honor, because every finding they made related to their incorrect belief that Ms. Robinson had violated those UPL rules. And all of their findings, as was pointed out earlier, are not supported by the record. For example, no one in the hearing had a copy of the relevant rules that were in place during that time. So reading the hearing transcript, I think one can see a dramatic change from how the first hearing went and how the second hearing went. And I believe it would be more appropriate to focus on their assessment of her credibility during the first hearing.
What about how the committee assessed her character witnesses in the second hearing? As I read some of the testimony and exchange, the lawyer who testified on her behalf in particular, I could see how he could be perceived by the hearing committee as very squirrely and evasive, because his responses were very lawyer-like and often answering a question with a question before actually answering. Did the committee make a clear finding of credibility or lack of credibility for the individual witnesses on her behalf?
They did. They ultimately found that both of the witnesses were credible, but that they simply did not know her well enough for their opinions to matter very much. You're absolutely right to point out how the testimony went in that hearing with that lawyer. There were difficult issues because certain information was still privileged. There was certainly tension there. But at the end of the day, the committee said these are longstanding members of the bar, well respected, certainly understood the violations, but they just, for example, the one gentleman said he had talked to her approximately 4 times a year. And that doesn't show that they really know her well enough to vouch.
Well, then what do we do with that? Or you're not asking us to assess the witness's credibility based on the record differently than the hearing committee did, or are you asking us to disregard their assessment that the fact that these witnesses didn't know Ms. Robinson long enough? What do we do with that?
My answer to that, excuse me, Your Honor, I didn't mean to speak over you.
No, that's okay.
My answer to that is to look back at all the precedents from the Court of Appeals that, virtually all of the petitions that have been denied based on inadequate witness testimony was because the witnesses who were called to testify did not understand the violations. That is what the precedents of this court guide lawyers seeking reinstatement to focus on. And there is no case law stating that the personal versus professional nature or, the number of times a year they speak are other factors. So I believe, in a sense, there was an error of law in focusing on the wrong elements of the testimony. I also think, however, you're correct that, the court is to afford deference to the credibility determinations, provided it's supported by substantial evidence. But in the overall assessment of character, the witnesses are just one piece. And as we talked about a few minutes ago, there are so many other things that contributed to her showing of character. So my specific—
But counsel, you said that, this is maybe a point in your favor, but you just said we're supposed to defer to the credibility findings. And your point is that the committee actually found these 2 witnesses credible.
Right.
Okay.
Right. They just put very little weight on the testimony for reasons I don't think are consistent with the precedents of this court. So, we are hopeful that in the court's de novo review, while obviously deferring to credibility findings, the weight will be assessed in line with other cases where the focus has been very clearly, the committee even said in its opinion, a layperson might think that what Ms. Robinson did in 2012 and 2013 is understandable. A lawyer is the type of person who is going to understand why it was not. And I think their opinions as lawyers are more persuasive and should carry more weight, rather than if it was a close personal friend who wouldn't have understood the gravity of the violation or all the things that ensued afterwards.
What relief would you be seeking here?
Well, that's a good question. I don't believe under the rules or Rule 11 provides any type of remand ability. Obviously, this is a de novo review by the court, and we would ask that the court assess the record, stopping at the end of the first hearing, because everything in the second hearing is so bound up with UPL that it's not an accurate way to assess. And in light of the fact that all of the other 4 Roundtree factors were found to favor reinstatement, and this very different view of the character question, given this very fundamental shift, now that we know all of the UPL issues are not persuasive, or given that, we'd ask that the court grant Ms. Robinson's petition for reinstatement.
All right, thank you.
Thank you.
And you did reserve some time for a rebuttal.
Yes, 4 minutes.
Mr. Metzler?
Thank you, Your Honor. Chief Judge Blackburn Rigsby, and may it please the court, Jack Metzler for the Office of Disciplinary Counsel. I want to start just by noting, and as the panel has noted already, that we're in a different posture than when disciplinary counsel usually appears before you, in that this is a reinstatement proceeding, and here it was the petitioner, Ms. Robinson's, burden to show by clear and convincing evidence, the standard that our office is very familiar with, that she has reformed herself and meets the factors described in the Roundtree case that support her readmission to the bar. And the 2 that are most important here are the first one, which is the seriousness of the conduct, and the 4th one, her present character. And I bring up the first factor because when the underlying misconduct that led to the discipline is closely bound up with the role of an attorney, the court applies heightened scrutiny to the remaining factors. And here, I think there's no question that the underlying conduct was very closely tied to an attorney's role. Ms. Robinson betrayed her client.
Mr. Metzler, can I just interject briefly here? But I thought really the only factor at issue was the 4th factor of good character, that the committee determined that she had met all the other factors.
Well, it's hard to say how you meet the seriousness. You consider the seriousness of the underlying misconduct, and that affects how you evaluate the other factors. Yes, she found that the hearing committee's decision was primarily that she didn't meet the character factor, but the seriousness of the misconduct instructs how that factor and the others should be evaluated.
But I don't think your counsel on the other side disagrees that factor 1 triggered some heightened application or heightened review as to the other factors. So I tend to think Chief Judge is right that we're really focused on 4, and I think we assume that we're applying sort of a heightened review as to all of the factors, including factor 4.
I completely agree, and I'll move on to that. And so the 4th factor requires that the petitioner establish by clear and convincing evidence, again, that they have the present character to resume the practice of law. And the court has held in it case after case that they should put on live witnesses that are in a position to testify about their changed character. And, I have been asked by the Board on Professional Responsibility and by this court, what sort of showing does, this is not an easy thing to show. And I'd say, well, it's also not an easy thing to do. Showing that your character has changed requires self-reflection. Think back, what led me to disregard my responsibilities as an attorney and follow some other path instead. And just to quickly review what the underlying misconduct was here, this was a case in which Ms. Robinson, for a prolonged period of time, fed confidential information about her client to an opposing party and to the government. But that wasn't the only violation. She also agreed in the negotiated discipline that she intentionally was trying to harm her client, and she engaged in dishonesty by continuing to represent the client while not telling them that she was stabbing them in the back. So
Mr. Metzler, you're going back to the seriousness again. I mean, I realize you're offering it in terms of character, but what do we make of the fact that the hearing committee, I think your main argument, you're putting a lot into the witnesses' testimony, not living up to what it needs to live up to. But your opponent does quote this language from the hearing committee saying its concerns about petitioner's character would have been assuaged had she admitted to the unlawful or unauthorized practice of law, which makes me think that they're trying to answer the question that you're telling us about here. And they're thinking the thing that's really moving us is this, body of evidence and testimony that I feel like we all kind of agree we're not going to rely on.
Sure. Well, so I agree. If you look at that one sentence alone, you might conclude that the UPL is really what prevented the hearing committee from finding in favor of Ms. Robinson on this factor. But I don't think I don't think it's, that was in the midst of admittedly a long discussion of UPL, and the hearing committee clearly did not believe they weren't convinced by the testimony of Ms. Robinson at that second hearing. But I think the task, if you set aside the UPL, is really to look at the quantum. And I agree with Ms. with my friend that the best way to look at it is to look at the testimony as of the end of the hearing. And our post-hearing brief came to the same conclusion that the hearing committee did. We thought that the witnesses just didn't know her well enough to opine on her present character. And if you in the first part of the argument, we heard, well, the court's cases are based on the extent to which the witnesses know about the misconduct. And I would say many of them are, but the reason we're concerned about that is that it affects their ability to give credible and their basis for opining about the witness's character. They can't really evaluate character if they don't know what she did. Well, here, the task is to show changed character, and these witnesses had hardly any contact with her after her actual misconduct occurred. So they just weren't in a position, not because they didn't know about the misconduct, but because they just didn't have a basis to say, well, she had changed her character. She had done the self-reflection that I talked about earlier. And
I mean, so you're really, sorry to interrupt you, but you're putting attorneys in a very difficult position here to find witnesses who, the conduct here occurred, even if we include the Wisconsin conduct, but certainly the alleged, not the UPL conduct, but the conduct that formed the basis of the initial investigation occurred. Sorry, I'm getting confused now. Some 12 years ago. Is that right? 12, 13 years ago?
about right, yeah.
Okay, so you're asking for someone who knew her then, knows her now, and knew her in between, and knew enough about the nature of the misconduct back then, and knows her well enough now to opine on her character and her changed character. For most people, you're talking about probably a spouse or a family member or something like that, and I think we have cases that have given less weight to such witnesses, family members, because obviously they have certain biases, and they're not impartial. So that it seems like a very difficult position that you're putting attorneys in.
So I don't think that I wouldn't say we're asking quite as much as your question suggests. What I think these witnesses need to be are people who can opine about the person's changed character, and that could be a very recent person who has heard them, who's had discussions with them about the misconduct and how they felt about it, and what they did to change their to the self-reflection that they had done and the realizations that they had come to. And just to be clear, I don't think the fact that a witness has a professional relationship on its own would be a reason to completely discount that witness. And nor do I think that that's what the hearing committee found. We place, the hearing committee's job is to evaluate these witnesses and to determine whether they see them in person, they get to evaluate their demeanor and decide whether they are credible. And I agree that the hearing committee didn't find that these witnesses were not credible, but it did find that they just didn't know her well enough to talk about her changed character.
What
Well,
about the letter to the Wisconsin bar? Why do you discount that? And what were the circumstances? Is it accurate that the Ms. Robinson was trying to had scheduling difficulties getting that person in as a witness, or why is that not more relevant?
Well, the court has said on many occasions, and I believe Ms. Robinson quotes it in her brief, that an applicant for readmission is expected to put on live witnesses exactly so, and the reason for that is exactly so the hearing committee can evaluate their demeanor and their manner of testifying and decide whether they're credible. So the letter, I wouldn't say it should be given zero weight. But I don't think that it is enough to establish the factor where, again, this isn't just a preponderance of the evidence. It is clear and convincing evidence that there should be a firm holding in the mind of the decision maker that the fact has been established.
well, Mr. Metzler, can I just interject again briefly on this? I want to go back to the question that Judge Schenker asked about what are we making this sort of the impossible mission almost for the attorneys in support of their reinstatement. It seems to me that you don't have to, if the committee found the lawyers who she put forward as her character witnesses to be established, I forgot the quote in the record, but they found them to be lawyers of good rapport, and lawyers of good character, and they also understood the issue for which at least a part of her initial discipline was based on. It seems to me it doesn't have to come from all one witness. If they're able to say, based on their experience as credible attorneys who are noted to be of good character in their fields, that she acted and is acting with similar good professional character, I don't see why that wouldn't be enough, particularly where they're found to be credible by the hearing commission. It almost seems to me like you're saying they have to have been borne witness to her, excuse the colloquial term, her baptism anew as a new person, and that doesn't seem to track. They can say what is and what they see, and without countering testimony that, oh no, that's not true, from another witness. Why shouldn't their credible testimony be enough? And here we don't have other witnesses coming in at this reinstatement saying, oh no, she's definitely not rehabilitated. So I guess I'm not seeing why these witnesses that she put forward were given so little weight. I mean, they prove what they see and what they know about her, and they're deemed to be good character themselves in the legal profession. That seems to me to carry a great deal of weight. I mean, what is it that you think the committee wanted to hear from some witness that they didn't hear, other than length of time? I have friends, as many of us do, that have known me since elementary school. I may not have seen them since then, but if they came to testify, I that length of time of not having been in contact, I'm not so sure that that could be discounted so easily. Here, they have a solid frame of reference for knowing her professionally, which is what we're really concerned about. Is her professional behavior and character going to be that which we think is necessary to practice law here?
Well, I think the answer is to just step back for a moment and think of the posture that we are in. This reinstatement proceeding happens. This isn't an initial application for admission to the bar. This is a proceeding that happens after the court has said there is either the person's been disbarred or they are suspended with fitness. And the reason for fitness is that the court has a serious concern that the person about whether the person will follow the ethical guidelines in the future. And so they don't get the benefit of the doubt. If they come in and they just say, I would like to be readmitted, the answer is no. They have to meet a burden, and they do that before a hearing committee, and we trust hearing committees to make these evaluations. And I think if you take out everything in the I can't tell you exactly what the hearing committee wanted to hear, but what I can tell you is that they were not convinced that these witnesses were in a position to talk about Ms. Robinson's changed character. And that's the sort of finding that this court has deference to. Now, if you thought that this was, I suppose the argument, I think, from my friend is that the hearing committee was infected somehow. Their entire assessment of this factor was infected by the unauthorized practice discussion. And if you thought that, I would submit, well, it's unlikely this hearing committee is going to come to a different conclusion if there were a remand. And it's not really appropriate for the court to engage in a de novo review of these witnesses who were not before this court and whose evaluation was by the hearing committee. So I would say, I would submit that if you wanted a remedy, it would be to under Section 19. When a petition for reinstatement is denied, ordinarily the person can't reapply for another year. So, but unless the order denying reinstatement provides otherwise. So I would say the court could deny reinstatement and, shorten or eliminate her opportunity to reapply, and she could start the process over sooner before another hearing committee and
But
have.
the hearing committee, I mean, I don't want to keep going around in circles. You've already acknowledged that the hearing committee found these two witnesses credible, so we wouldn't be undermining a credibility finding. And there were no actual findings of fact related to the witness's testimony. It was basically essentially a legal conclusion about whether their testimony gets a certain amount of weight. And that's something that I think our cases say we do review de novo. So I'm not quite convinced on that point.
Well, I suppose the conclusion that the hearing committee came to that I think would be due deference is that these witnesses didn't know her very well, and that they were not in a position to opine about her changed character. I mean, if you take the lawyer witness, for example, he really didn't have much contact at all with her, Christmas cards and the like, after her discipline. And the question isn't what is their overall character since they were in kindergarten. The question is, have they reformed their character since they engaged in misconduct? And I don't want to harp too much on the seriousness of the misconduct, but I do think it's important to note this is, this is an action Ms. Robinson intentionally took. She knew it was wrong. She may have thought she was motivated by something else, that the company was doing wrong and she could remedy it, but she knew she was not supposed to reveal confidential information. She knew she was not supposed to be dishonest, and she admitted that she did this to intentionally harm her client. And the question is, has she figured out what it is about herself that led her to follow that path, rather than put the her professional responsibility at the fore. And my time has expired, but so if there are no further questions, I'm happy to submit.
Can I just ask you one quick question? Sorry, Chief, if you were about to
No, no.
ask what on remedy, I'm not saying we're here, and I'm not saying you agree with your colleague on the other side on the substance here, of course, but if we were to agree with your colleague on the other side, do you agree that remedy-wise, there's no real process for a remand, and that I think you said we could either accept the report but change the amount of time by which she can reapply, or could we just reject the report and order reinstatement? I'm not saying you would support that on the substance here, but as a process matter.
As a process matter, I mean, I would disagree probably with the reasons behind it. I don't think there is any. I can imagine you might find a way to write an opinion that grants reinstatement. That would be very unusual in our system, and I'm not sure that there is a express procedure for remand. But I also I'm not familiar with anything that would prohibit a remand either. So it's I suppose you could order a remand and ask the hearing committee to reconsider this element without regard to as a process matter. I think it was, as our brief has said, I think it was fine for them to ask about the UPL. But I think in these circumstances, you certainly could remand and say disregard that evidence and reissue your report based on the evidence from the original hearing. I don't see why that would be. We wouldn't seek rehearing in bank. Let's put it that way.
Thank you.
Thank you, Mr. Metzler. Ms. Lociero?
Cicero, thank you, Your Honor.
Lociero, thank you.
It's a very difficult name to pronounce. It took me quite some time to figure it out myself.
Cicero.
Yes, thank you. I'd like to start with Judge Shanker's question about procedure. Rule 11 states that the board report is considered, the hearing committee and the court shall grant or deny. However, the court does have inherent authority, and I believe the power to remand would be part of that generally. I hear Mr. Metzger's proposal that perhaps the panel would decide to remove the 1-year waiting period. Certainly, if the other option was denial, we would gratefully accept that relief or a remand. But I would point out that Ms. Robinson filed this petition in 2021. The conduct occurred in 2012 and 2013. And so while the 1-year waiting period being removed would be obviously quite helpful, it really, this is a very long, very arduous path towards reinstatement. Mr. Metzger said something important, that it is, the question of character is not concrete. It is really hard to show that. And some of the examples that he gave in his argument is that you look to whether there's been self-reflection. You look if the person explains what got them there and how they've now changed. And I completely agree. That's a way to assess character. And I would ask that the court look at, again, the transcript of the first hearing where Ms. Robinson spoke eloquently and very humbly about the mistakes she made. She has not, and we are not at all disputing the very serious nature of her misconduct. But given the focus on it, I will point out that the committee that decided the discipline back in 2019 recognized she didn't act out of pecuniary interest. It was a misguided belief that she could do something as a whistleblower. That does not at all change that it was misconduct, but it does provide some context. I also want to say a little bit about the witnesses. We've talked a lot about them, but I just want to point out there was a comment that Mr. Kramer, for example, really only exchanged Christmas cards with Ms. Robinson. But he also testified about how in the recent past, Ms. Robinson, who had a client in her consulting business, asked Mr. Kramer to represent them in a legal matter. And so they worked together. Ms. Robinson was not able to practice law, but they worked together, and that he was confident in her abilities and she carried herself ethically, etc. And as to Mr. Daniels, I think Judge Blackburn-Rigsby, you made a very good point that certainly resonated with me. I have friends who mean the world to me, who I've known for a very long time, who I talk to 4 or 5 times a year. Those calls are very significant calls. And those are the type of people who can speak to someone's character. I think the last point I'll make is just that at some point, we start to lose the forest for the trees. I really appreciate each of the panel members acknowledging the practical difficulties that face someone seeking reinstatement. You don't know exactly what the hearing committee wants, and so all you can do is read the decisions of the Court of Appeals, the precedential decisions, and focus on the guidance that has been provided, which is that the witnesses must understand the misconduct and speak to that. You're absolutely right. Leslie Haley was not able to attend the hearing. She became an assistant attorney general in Virginia, and she had a mandatory meeting conflict. She absolutely could not attend. These are all people who understand what Ms. Robinson did wrong, and they vouched for her. And the last thing I'll just say, Ms. Robinson stood firm and was honest and truthful with the committee. She said, it was a long time ago, but I remember that I understood there was a federal exception. Now, as Mr. Metzger pointed out, the respondent has a deep hole to kind of climb out of in any reinstatement matter. I'll submit that after the UPL issue, that hole was so deep that there was virtually nothing that Ms. Robinson was going to do to satisfy the 4th factor. And I do believe that may be an issue on remand as well. Overall, we ask not that the court discount any credibility finding, but that in performing its de novo review and considering all of the pieces of information in this record about character, that it provide Ms. Robinson with reinstatement.
All right. I'd like to thank both counsel for your briefs and arguments today, and we will take the matter under advisement. Thank you.
Thank you, Your Honors.
All right, and you're free to exit our virtual courtroom today.
Thank you. And thank you for accommodating my schedule this morning. I very much appreciated that.
Thank you. All right. Our second case this morning, if counsel are both here, yes, is Gerardo Varela versus Advanced Construction Group, LLC. Counsel, are you ready to proceed?
Ready, Your Honor. Good morning.
All right. Mr. Everett?
Yes, Your Honor. Thank you. May it please the court, with the court's permission, I'd like to reserve 2 minutes for rebuttal.
All right. Thank you.
There are 2 issues on appeal that we're asking the court to address from our trial. The first is whether in a negligent employment case, is the employee or can the employee be an intervening cause? The second is whether the trial court abused its discretion in answering the jury's note about whether the shooter, employee, defendant Jones, was an intervening cause. Now,
So, Mr. Everett, in your brief, I guess in both parties' briefs, you spent significant time discussing the heightened standard and the ordinary standard that we should apply here. Is it your position that an intervening cause instruction is not appropriate where there's a heightened foreseeability standard or requirement?
So it's our position that this is not a heightened foreseeability case. That because of the employer-employee relationship, it creates a special relationship, and that reduces what would normally be the heightened standard to just simple regular foreseeability. And I believe the trial court got that part of it correct. As I've noted in her brief, Judge Collier at the U.S. District Court provides an exhaustive history of the District of Columbia's case law on this issue.
Did I state I may have stated my question backwards to you.
Okay.
I apologize for that.
I might have misheard it.
Yes, no, you didn't. I just misstated. I understand that you believe that an ordinary foreseeability standard should apply here. And I had understood that you conceded that the intervening cause instruction, although initially objecting, ultimately conceded that that was appropriate for the judge to give that instruction. Is that correct?
No, Your Honor. During the discussion on intervening cause happened several times during the course of the trial and on different days. We objected to the inclusion of the intervening cause instruction when we were discussing jury instructions on, I might have been day 4, but we objected, had an extensive argument about it. It got re-raised later when we were discussing the issue, and the court and I again still maintain my objection to the inclusion of that instruction, and I believe based on that alone the issue is preserved. Then at one point during a lengthy discussion with the court described there was an earlier fist fight before the shooting between Defendant Jones and the workers for my client, his employees. And the court suggested that could that be an intervening cause, that the fist fight earlier in the day. And I initially, yes, I agreed that it might be because those workers are not parties to the case, which is our whole argument, that this is not an intervening cause because it's a party, it's not a stranger, it's not somebody that suddenly came in later. In the, I guess, academic discussion about whether the workers could be an intervening cause, I initially agreed, yes, they could be because they're not a party. But looking at it, I think that there's a causal break there between the workers didn't harm Mr. Varela. The only person that harmed Mr. Varela is the shooter, Defendant Jones. And so looking back in hindsight, yes, I believe that there's a causal break there. I believe that we have preserved this issue. We have not conceded anything and still maintain that Defendant Jones cannot be an intervening cause. And the jury was. Yes, sir.
Sorry, you started to reference the Kohler case in the federal district court, which has a pretty extensive analysis of our case law and seems to come to the conclusion that the employee could be viewed under these circumstances where there's a separate criminal act as the point of the intervening cause.
Yes, sir. The Kohler case, really the only language in that opinion that addresses whether the shooter is an intervening cause or a third party, it described the employee as a third person subject to defendant's control or supervision. And that's the only language that's contained in that opinion. The Judge Collier certainly does not say that that this person is an intervening cause. It doesn't even doesn't describe them as just simply calling the shooter a third person doesn't necessarily mean that they're outside of the special relationship that the court correctly identifies.
So if you look at our case, Boykin, this might be consistent with what you're saying Kohler said. So we described we said the injury was caused by the intervening criminal act of a third party. But I guess we then went on to say that therefore this foreseeability test applies. And so am I understanding that your argument is that, yes, there's sort of a third party vis-a-vis the plaintiff-defendant relationship, meaning the employee, but it's still simply a foreseeability test and not a break in the causation test?
Yes, we are saying that this was completely foreseeable based on his history and his conduct during which that the defendants failed to take proper supervision steps. If I can address the Boykin case that Your Honor identifies, and as I discussed in the company's brief. So Boykin is a 1984 case, over 40 years old, and references a case that happened 4 years before that with Lacey versus District of Columbia. And the 1980 case, Lacey versus District of Columbia, I'll start there and then go to Boykin. The Lacey case is in a case where a employee janitor, so it is an employee, special relationship here, sexually assaulted a minor. And in that case, the court was considering whether the substantial factor test should be applied. And the court ultimately said that the substantial factor test was appropriate, which the substantial factor test is actually a part of the current jury instruction. But in Lacey, the court discussed all of the jury instructions regarding causation. The jury instructions given in Lacey were proximate cause, concurring cause, and a non-pattern substantial factor test. It does not give an intervening cause instruction in Lacey. And so the court is, of course, correct that the language is contained in Lacey and then repeated in Boykin 4 years later, that an immediate cause of injury complained of in that instant case was the intervening criminal act of a third party. It does, of course, contain that language, but it's dicta. The holding on the case is whether the substantial factor test should be included. So, and defendants have taken this 45-year-old opinion and stretched it to the point where now they want the court to establish new law.
What about the Schechter case? Schechter versus Merchants Home Delivery, which is a 2006 case. It's more recent, but there essentially we found that the theft by an employee, a criminal act, provided sufficient question to go to the jury on the issue of whether or not this was foreseeable. And doesn't it sort of validate this notion that an employee could be considered a third-party criminal actor for this purpose? And I guess isn't the question we should be asking whether criminal acts by any person in these scenarios could be the intervening cause, whether it's the employee acting or whether it's some other new person introduced into the equation.
Yes, Your Honor, I believe that.
Questions about Schechter and then about the criminal act.
I'll do my best. But I think you're directly on point. Is can anybody be an intervening cause, whether it's the employee or somebody else? We say no. The employee is not an intervening cause because of the relationship between the employer and the employee. It gives rise to a duty for the employer to protect the public. If it was an independent person, a stranger, someone the employer didn't know, then yes, intervening cause instruction is appropriate.
Well, but I agree with that to a point. And that point being when the employee commits a criminal act that is unforeseen against someone. Why isn't that an intervening cause even in the context of an employee-employer relationship?
If it's unforeseen, then it's not negligent employment. So we don't even get to intervening cause. It has to be foreseeable.
I'm sorry, I feel like I'm misunderstanding the basic questions here, and maybe you can tell me where I'm going wrong. But I thought the question was sort of the level of specificity of the foreseeability that's required. And when we look at the instruction that Judge Edelman gave, he's requiring that the third person's or if a reasonably prudent person in these circumstances would have anticipated that the third person's act or omission being very specific about, you have to foresee that he would commit a shooting, I thought that that's contrary to what Kohler was talking about in its description of the standard that would apply in a situation like this, which Kohler seems to indicate is, I guess, the control, the control type of, at first Kohler suggests that maybe the special relationship, which is meant to be employer or the parties, might apply to employer employee, but then it really goes on to get to the point where you think it's really talking about the control category. But why isn't that the question, whether this instruction that Judge Edelman gave is too specific? It requires too specific foreseeability under Kohler's, very thorough description of our case law.
Yes, Your Honor. I believe that the court got the level of foreseeability correct, that it's regular foreseeability, that it's not heightened foreseeability, which is consistent with the Kohler opinion.
What about, Kohler talks about Giles and, where it says the Giles instruction was, it is incumbent upon a party to show that an employer knew or should have known its employee behaved in a dangerous or otherwise incompetent manner. It's not like would have known is going to shoot somebody. And it also refers to the restatement on agency, which talks about the quality of the knowledge, the person, where I'll try to find that that language. But I think Giles is one of our cases, and that's the language it uses.
Yes, Your Honor. The problem with Giles is that there's no special relationship there. In that case, the court found that there was no employee-employer relationship. So it doesn't have so it has a heightened duty because there is no relationship there, and there was no control either. So it didn't fall within either category. So in Giles, it's not regular foreseeability. It would there's no liability. And on agency, Your Honor, I don't believe that agency is directly our issue either, because agency is really respondeat superior. This isn't a respondeat superior case because the shooting happened outside the scope of the employment. There's no dispute that it was after hours or that he shouldn't have been working at the time. The fact is that he was a very violent criminal with many felonies, and the employer should have done more to protect the public against him.
Is that right, that this was outside the scope of employment?
Yes, Your Honor. That issue wasn't really before the court, but I believe that's correct. So our fact pattern is that the shooter made a delivery to the elementary school during the day. He gets into a dispute with some workers on the scene. He leaves, comes back, and fist fights them. Mr. Varela, my client, is not present during any of that. That's not disputed. And then once he loses the fist fight, later in the afternoon, he goes back to the company warehouse, switches out his vehicles, goes and gets a gun, and comes back to the scene at roughly 4 p.m. or so in a company vehicle. That was not a part of our cause of action because because of the employer-employee relationship, there's liability even outside the scope of employment because of the special relationship that exists.
I did find that restatement language that I thought was relevant, that I think you think is not relevant, but it says the plaintiff has to show the harm is caused by the quality of the employee, which the employer had reason to suppose would be likely to cause harm. So it's not like, the specific shooting, but the quality of the employee.
Right. And here we do have testimony that Mr. Jones was a good employee up until the incident where he testifies he was jumped by other employees. So
if I can.
That would seem to negate your contention that there's more that the employer should have done to ensure against an incident like this.
Your Honor, Mr. Jones was employed for 2 months. when he shot somebody in the face. He was employed at a different warehouse in a different state with nobody looking after him. The only supervision he got was one phone call a day, giving him his work instructions for his delivery.
I mean, isn't this not really before us anyway? Because the jury already found negligent hiring and supervision.
Yes, Your Honor,
So
correct.
it's only a causation question now, or well, you can call it a causation question or foreseeability question, but whether they had reason to know that he was, whether they had knowledge of the things that made him not suitable for hiring that's not before us. Is that right?
That's correct, Your Honor. The jury already answered that they were negligent in their hiring and supervision. If the court would look, I'll wrap up here unless there's more questions, at least on this. The intervening cause instruction that we've been talking about, not a single case cited in the comments is a negligent employment case, because it's apples and oranges. Simply the negligent employment does not, the employee is not an intervening cause. It cannot be. And the court and the company in this case is asking the court to make new law on this issue. And I don't believe it's consistent with what the court has put forward in the past.
All right, thank you. And I know you reserved some time for rebuttal. Mr. Hetherington?
Good morning. May it please the court.
Good morning.
This is a case involving really two very narrow issues. One, the intervening cause instruction and the court's response to the jury note. The plaintiff's entire argument, or the appellant's entire argument, is based on this special relationship, which they argue somehow lowers the standard of foreseeability. But we still get back to the issue of foreseeability. And their argument on the intervening cause instruction is that it only applies in the absence of an employer-employee relationship, and that this creates some kind of special relationship or control by the employee. Now, I'm glad that Mr. Everett conceded that this was an act which took place outside the scope of his employment. And if we look at the timeline, which again was undisputed, okay, he's jumped at, and this was all by video evidence, which was mentioned in the record. He was jumped at 2:14 p.m. He then arrives back at the warehouse at 2:36 p.m. It is undisputed that as of that time at 2:36 p.m., he was finished for the day. He was finished with his employment. He then took a vehicle without authorization, apparently went home, changed his clothes, and then returned to the scene. And at approximately 4 p.m. Is when the shooting takes place.
Mr. Hetherington, could I ask you, as a threshold matter, whether there are any cases that you could cite to where there's been a clear holding that an intervening cause in a negligent hiring case could be the employee themselves based on their actions?
On that specific issue, Your Honor, no, but I think that both Boykin and Kohler, by analysis and by implication, indicate that an employee can be a third-party criminal actor. I think that it's clear in both of those cases that they can be. And we then return to the negligent hiring and supervision, which was an instruction that was given. And there's really no need to even go beyond that particular instruction. It was an instruction that Mr. Everett did not object to. And the jury, in looking at the instructions that they were given and the 4 elements, in fact, they had a question earlier on in the proceeding as to whether or not they had to find all 4 elements. The court correctly responded by saying, yes, you have to find all 4 elements. And I think that the most important one of those is the 4th, was ACG's negligence in hiring and supervising Mr. Jones, was that a substantial factor? So again, it goes back to causation. It goes back to causation, and it goes back to foreseeability, which was in the case. And that was argued quite extensively to the jury, that this was foreseeable because of this, what has been characterized as a violent criminal history with multiple felonies.
But I guess the question is foreseeability of what? Does the person have to have foreseen, you know, unfitness or, yeah, or as the intervening cause instruction says, the later acts or omissions, which makes it sound like you would foresee that something like this, a violent shooting, would happen. And, you know, what is the standard? And I think that's the question of it. Maybe you say the intervening cause instruction maybe wasn't necessary because they're both talking about foreseeability, but foreseeability of what?
Well, Your Honor, I do believe that that is addressed in the Kohler opinion, where the Kohler opinion specifically said the foreseeability of the risk of harm exists when the defendant employer knows or should knows that its employee is peculiarly likely to commit intentional or reckless misconduct. So it would be our position that they can't just say that it's foreseeable that he would commit some crime, but in fact, it would be the crime that he actually did commit, i.e. going and getting a gun, changing clothes, returning to the scene, and shooting somebody 3 times.
I'm sorry. I thought your position was that the peculiarly foreseeable standard was not applicable here, not because of a special relationship between ACG and Mr. Varela, which there wasn't one, I think, but between ACG, the second prong, which is the employer-employee relationship. I thought you had conceded that we were at standard foreseeability.
We are at standard foreseeability. That would be our position. Standard foreseeability, which was in the case, which was argued, which was specifically addressed in both the negligent hiring and supervision instruction and the intervening cause instruction. They have to be able to foresee. I mean, to the extent he committed any felonies, they were many years ago. I think the closest one in time was 18 years ago, if I remember correctly. And then he had 3 subsequent simple possession charges that were subsequently expunged.
But do you agree that there's a difference between what the initial standard jury instruction for negligent employment says, which is ACG knew or should have known that Mr. Jones was unfit and that his unfitness created a risk to others, versus the intervening cause instruction, which is a reasonably prudent person in ACG circumstances would not have anticipated the later acts or omissions like these specific acts. Do you think those are different?
Well, Your Honor, I guess the argument would be, was he unfit to perform what he was hired for? And there was no evidence that he was unfit to perform the job for which he was hired. We're talking about an employee who, as was pointed out earlier, was a good employee, had no problems at all, came with references, and therefore, as far as whether or not it was foreseeable, that was an issue in the case, and the jury decided that it was not.
Well, I thought our focus, and I see we have lots of thoughts and views on how to look at this, and we're just trying to, all right, I'm just trying to hone in on it a little more precisely. Just to piggyback on Judge Beckwith's question, isn't it factor 4 in the instruction 522 on negligent hiring that creates a potential conflict with instruction 514 on intervening cause. That fourth prong talks about whether or not ACG's negligence in hiring and supervising Mr. Jones was a substantial factor in causing Mr. Varela's harm. And
I think it's one and the same, Your Honor. It still gets back to foreseeability and causation. Whether they negligently hired him, was that negligent hiring a substantial factor? And that also goes to the instruction on intervening cause. Was it a cause of what happened to Mr. Varela? And again, that was a jury issue. That was argued and was properly before the jury. I know that Judge Edelman pointed out that perhaps they overlap a little bit, but there are many instructions that overlap. And he ultimately concluded within his discretion that giving both of those instructions was going to aid the jury in deciding the case, and therefore provided both of the instructions so that the jury could consider all of those issues.
Do you think 514 was necessary instruction?
I do, Your Honor. I think it was necessary, again, even though they overlap. I think it was necessary
What does
because
it add?
it adds an additional element on the issue of causation. Okay, was it a cause? Was the negligence a cause, or was it the criminal act which was the cause? And I think that that's what it adds. I know that my time is running short, and I wanted to address the jury note specifically. As far as the jury note is concerned, it's been raised that basically Judge Edelman took away the province of the jury and decided the issue that this was a criminal act. You'll note, it's curious because you'll note from the jury note itself, it was originally written as does. They crossed it out and they indicated can. And Judge Edelman, again, within his discretion and indicating in the record that it was his preference to answer specific jury notes. And again, the question was, can it be? And he responded, yes. Now, if the instruction or the note had been as originally written, does, then obviously that would have taken away the jury's function. If the court was to respond and say, does it? Yes. Then the court has made the factual determination that the jury needs to make. And in this particular case, he responded yes, told them that he couldn't give examples, and referred them to the additional instructions for deciding on that particular issue. And I do, in an earlier question that was asked, I do believe, if you look at the record, that Mr. Everett did concede that the intervening cause instruction was appropriate, because there was this additional issue raised as to whether or not it was the fight or whether or not it was the shooting. And sorry, John. Mr. Everett conceded that yes, that could possibly be an intervening cause as well. So with that concession, saying that yes, the fight could have been an intervening cause, then the instruction itself was appropriate. I think that the bottom line to all of this, that it was a question of foreseeability. Judge Edelman, within his discretion, determined that both of the instructions would aid the jury in rendering their decision, and that's why they were given.
Mr. Hetherington, can I ask you one more time?
Sure.
Do you agree that if we were to hold that the employee could be the third party intervening and superseding cause for the injury to Mr. Varela, that we would be the first court explicitly making that holding?
Well, Your Honor, I guess the note is when you say explicitly. I do think both the Kohler and Boykin opinions do mention that concept, although they may not have specifically said an employee cannot be a third party.
Okay, then
Yeah, do we have other, just a quick follow-up, I'm sorry, are there other cases you're aware of where, in our jurisdiction or others, where there's been a specific holding that a criminal act essentially, in most instances, can be viewed as an intervening causation?
Well, Your Honor, it has to be foreseeable by the employer in order for it to be actionable and for them to be responsible for it.
and so you would agree your position is not, I mean, it seems like the natural end result of your position is that anytime there's a criminal act by an employee, it basically precludes a negligent hiring and supervision claim. I take it that's not your position.
No, Your Honor, because as in the Kohler case, it was foreseeable because of the fact that he had the criminal actor in that case had exhibited bizarre behavior in the months prior to the incident. In this case, it's exactly the opposite. There was absolutely no reason, nothing that they determined through their investigation of him as an employee by checking references, etc., and had no problems with him whatsoever.
All right, and you mentioned that he was acting outside the scope of his employment, sort of going more toward the agency argument, but that wasn't an argument in this case below, was it? Before the
No, Your Honor, but it gets to it goes to the special relationship that's being argued by Mr. Everett in this case, as to whether or not there was a special relationship and there was some element of control at the time that he committed the criminal act.
And you would say there wasn't?
I would say there was not.
Okay.
And I think the facts bear that out. Again, I mentioned the timeline.
Notwithstanding the employee-employer relationship, which was still technically, which was still in effect, even though you argue that he was not on duty essentially at the time he took the truck and went back to shoot Mr. Varela.
Yeah, and Mr. Everett has already pointed out that that was undisputed.
Right, but he was still an employee. He hadn't been terminated, I guess. So
Yes, he had technically been an employee, but if you follow that logic, then at any time, if someone is an employee, I mean, suppose he had gone out that night at 8 o'clock and shot somebody else. So you can't extend that out, is the point that I'm trying to make. Otherwise, any employee at any time who commits a criminal act, the employer would be responsible.
all right. Thank you, Mr. Hetherington. Mr. Everett, you've got
Thank you.
minutes for rebuttal. Can we
Yes,
just
ma'am.
pick up there? Because am I misunderstanding that seems to essentially be how I'm understanding your argument, that in the context of an employer-employee relationship, any criminal act that is committed by the employee would not be viewed as the third party intervening cause to create liability, even if you have the employee-employer relationship intact and it was negligent hiring.
Yes, Your Honor, the crime has to still be connected in some way to the employer-employee relationship. Counsel's example of where, an employee goes out and kills somebody and they're in the middle of the night, You can't hold the employer responsible. In that case, everybody who's employed and is in jail, their employer is potentially responsible for them. That's not the case. It has to still be connected in some way to the job and the work done. And Your Honor's question actually, I believe, connects nicely with a question from Judge Beckwith earlier about the level of foreseeability that's required. And what is the standard for the level of foreseeability? The court has said that the harm does not need to be particularly shown, but it has to be of similar nature. So there has to be some level of connection between the two. In this case, Mr. Varela was convicted and had felony convictions for violent crimes using a handgun. That's pretty close to what happened here. He didn't attempt to kill anybody in the past, but it's an escalating pattern of behavior along the way. Defendants don't get credit for the time that he was incarcerated and wasn't committing crimes out in the public either. They want to argue that these things are far in the distant past, but he was in jail for half that time. The point is that this was also raised by Judge Beckwith earlier, whether the connection between 522 negligent employment and 514 intervening cause, and whether there's, I believe, any discontinuity or disconnect between the two instructions. The intervening cause instruction describes specific acts, that specific acts should have been anticipated, but that's not the standard. As I was just saying, the standard is that they have to be of the like and kind. They have to be similar in nature. That's more consistent with the negligent entrustment instruction, which uses the substantial factor test.
Where does the of the like and kind come from?
I would I don't want to misquote something because I'm sorry, I don't have that at my fingertips. It came to me as you were speaking, so I apologize. If you like, I can submit something.
Well, I agree that it's different. I just hadn't heard that language, but that's okay. Thank you.
I've read a lot of cases, so it's kind of
You and me both.
Yes, it comes in. So, and then I'll just wrap up. And Your Honor, Judge Blackburn Rigsby and Judge Shanker both raised issues about, well, what are the implications of what the company is asking you to do? And what happens is it's going to raise the bar. It makes it more difficult for injured folks who have been wronged by the negligence of a company to come forward with a claim. It also makes it it actually reduces the standard for what the employer should be looking for in their employees, because it now, to make this claim or to move forward with it, now we have an added level of intervening cause. So not only do you have the 4 elements of negligent employment, but now you also have intervening cause, which a claimant has to now overcome. So it makes it harder.
Well, but in the initial jury instruction on negligent hiring, you still have the 4th factor, which suggests causation, and perhaps foreseeability is underlying that as well. But the 4th factor is that ACG's negligence in hiring and supervising Mr. Jones was a substantial factor in causing harm. And I guess I have some trouble with the notion that just because someone had a prior criminal record at some point in the past, that prior record and the company's hiring them, notwithstanding that, is automatically a substantial factor in the harm that was caused to a third party by a decision to shoot them.
Yes, Your Honor. So we're not saying that, someone with a criminal history does not deserve to be employed. It's a factual inquiry done by the jury, and in this case, Well, I believe based on the note, why they answered no on causation was the intervening cause instruction, not actually number 4 here, because I believe that they got past this with question number 1 when the jury said that yes, that they were negligent in their employment. So the jury was already past this. But to answer the court's question, what we are not proposing, but suggesting is that, you know, if someone has a violent criminal history, but they're showing signs of rehabilitation, you don't suddenly give them the keys to the Ferrari. You know, you give them opportunities to earn trust, to build back their credit, and work into a role of trust where they're a valuable member of the community.
Okay. Any other questions? All right, with that, the court appreciates the briefs and arguments, both counsel. Thank you, and your case will be submitted, and you're free to exit our virtual courtroom at this time. Thank you.
Thank you, Your Honors. It was a pleasure.
This court is now adjourned.